Michael Gerrard will talk to us about global climate change, the current legal situation. He was chair of Columbia's renowned Earth Institute for a while and then became the founder and faculty director of the groundbreaking Sabin Center for Climate Change Law at Columbia University. He's among the foremost environmental lawyers in the nation, an advocate, litigator, teacher, and scholar who has pioneered cutting-edge legal tools and strategies for addressing climate change. I have been in a working group with him many years ago, and so know firsthand the great work that he's doing. Michael, over to you.
Thomas, thank you so much. It's a pleasure to be with you, even though it's remote. So I'm going to talk about the current legal situation with global climate change. I'm going to start by talking about the international climate agreements. Then I'll talk about how individual countries are doing. And then I'll move over to the litigation side, what's happening with litigation at the national, the transnational, and the international levels. So the first major global agreement on climate change was the United Nations Framework on Climate Change, the UNFCCC, which was negotiated as part of the Earth Summit in Rio in 1992. That was a time when there was really a good global consensus on the need to act on climate change. And President George H.W. Bush signed the agreement, as you can see here. The Senate ratified it as a treaty by a voice vote without dissent. This agreement set forth the objective. The ultimate objective of the convention is to achieve stabilization of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system. So that was the goal. However, the agreement did not specify how to do that. The agreement basically set forth the administrative process. So there would be a conference of the parties, which is the conference of all the countries that joined this agreement, which was about all of them, about all 195 countries, and various procedural mechanisms, but didn't really specify how to achieve the objective. There were annual conferences, but then in 1997, there was a major conference in Kyoto, Japan. And almost all countries in the world signed on to the Kyoto Protocol initially, except for the US and Australia. The US Senate had passed a resolution called the Burr-Hagel resolution, passed by a vote of 95-0, saying that the US should not sign on to any international climate agreement that did not require the major developing emitting countries, by which they really meant China and India, to reduce their emissions in the same way that the US would have to reduce ours. The agreement did not do that, so the US never signed. A few years later, Australia signed on, so the US became the only major country not to join the Kyoto Protocol. The Kyoto Protocol was designed to last until 2012, but in 2012, there was an agreement by a few countries to extend it out to 2020. But it was really just the countries in this dark green, which is mostly Europe and Australia, that agreed to sign on to this extension. The countries in light green didn't have any obligations to reduce their greenhouse gas emissions under the Kyoto Protocol, as I mentioned. The US stayed out, and Canada withdrew. So at the end, emissions representing maybe only about 10% of global emissions were covered by the Kyoto Protocol. Now, if we look at the text of the Kyoto Protocol, the key provision, the one that received the most attention, was the one I've highlighted in yellow here. The parties included in Annex 1, and the Annex 1 countries were basically the developed countries. shall ensure that their greenhouse gas emissions do not exceed certain percentages that are set forth in Annex B. So this is Annex B, and each of the countries on this list was required to reduce its emissions by 2012 below the 1990 levels by a certain percentage. So the U.S. Was supposed to reduce its emissions by 93%. To 93% of what they were in 1990. And we have all of these other countries making these commitments. This was the top-down mechanism of the Kyoto Protocol. Very noticeable. Not on this list. These are the Annex 1 countries. These are the developed countries, the only countries that had an emission reduction obligation. Not on this list are China or India or Brazil or Indonesia or several other major emitting countries. But in 1992, they didn't have much emission, and they were not obligated to reduce their emissions, which is why under the Senate resolution that U.S. never signed on. The agreement also had a lot of provisions to make it as easy as possible for all of these countries to achieve their emission reduction obligations. So we had several flexibility mechanisms. There was emissions trading, which allowed some countries maybe that would were able to emit more, to reduce their emissions more than they had to sell those excess emission reductions to countries that needed it because they themselves couldn't reduce their emissions. Overall, of the European countries was sort of considered a bubble, so they could trade with each other. There was also something called the Clean Development Mechanism, which was designed to allow the wealthy countries to pay entities in the developing world to reduce their emissions. Joint implementation was similar to that, just for the former Soviet states. That was the where flexibility. Where would you reduce it? The what flexibility is emissions reduction and sequestration of carbon dioxide would both count. There was a whole a list of several pollutants that were regulated, and you could mix and match. And very importantly, the agreement did not tell countries how to achieve their emission reductions, but each country would set its own measures. And then there was some flexibility in the timing. If we think how it turned out, we want to look at how it turned out. So the Kyoto target was a 5% reduction below 1990 levels by 2012. And if we look at the world as a whole, that was met, not the world as a whole, but just the Annex 1 countries, that was met. However, when you look at it more closely, that reduction was met almost entirely because of emissions reductions in Russia and Ukraine. And of course, the Soviet Union had just collapsed, and so Russia and Ukraine and the other former Soviet states had an economic collapse, which greatly reduced their greenhouse gas emissions. And so it was not because of any efforts explicitly to reduce greenhouse gas emissions, but it was because of the economic collapse of that part of the world that we had that reduction. All the other countries ended up being sort of flat, minus 2.7%, and the world overall reached minus 12.5, but almost entirely because of what happened in Russia and the other former Soviet states. Another very important thing that happened after the 1992 Rio Convention and the negotiation of the Framework Convention was what was happening with emissions from different countries. And so you see China's emissions soared beginning around 2000, with the liberalization of their economy. Their emissions soared. The U.S. emissions have slightly dropped, mostly because of fracking that has allowed natural gas to substitute for coal, but China's emissions soared. India's emissions have also gone up considerably, although they're still small, much smaller than the U.S. But the Framework Convention did not require China or India to reduce their emissions, or the other rapidly developing countries like Brazil. So this looks at the overall gross level of emissions, but another thing to look at is per capita emissions. And as we can see, US per capita emissions are the highest of any of the major emitting countries. They've gone down, again, largely because of fracking and increased energy efficiency and so forth. China's per capita emissions have gone considerably up. Back in 1992, our per capita emissions, the U.S. per capita emissions were maybe 10 times those of China. Now they're about twice those of China. So we still have higher per capita emissions, but not nearly the same kind of ratio. And India is down here. So India still has very low emissions. The Kyoto Protocol also, in the emission reduction obligations that it had, only looked at the emissions that took place inside a country. They did not take a look at the emissions that are due to a country's consumption of goods that are manufactured elsewhere. And so a lot of purchasing in the U.S. is of goods made in China. And so there's a difference between the territorial emissions, the emissions within a country, and its consumption emissions. So here, in China, at some points, as much as 20 or 25% of the emissions in China are to manufacture goods for export. And so they're not really consuming that. In the US, it's reversed. We have more consumption emissions than we do territorial emissions. And so we have major flows from production to consumption, major flows of the cause of greenhouse gas emissions from one country to another. So the Kyoto Protocol was really failing to achieve its objectives. The very big emitting countries of China and India didn't have any emission reduction obligations. The U.S., which was the biggest emitter until we were overtaken by China around 2007, never joined. And there were lots of other problems with it. And so it became clear that a new international agreement was going to be necessary. There were years of negotiation, and in 2000, the agreement was reached that they would try to come up with a new wonderful plan in 2015 at the annual climate conference in 2015, which took place in Paris. So the Paris negotiation, which went on for 2 weeks, although it was preceded by lots of preparatory meetings, ended with what was widely regarded as a wonderful success. And so here we have, Cristina Figueroa, who was executive secretary of the climate conference, Ban Ki-moon, the Secretary General of the UN, the foreign minister of France, who president of the conference, Francois Hollande, the president of France, all raising their arms in triumph with the final gaveling of the agreement. And a basic element of the Paris Climate Agreement was that rather than the top-down approach of the Kyoto Protocol, where each country was assigned a percentage emission reduction. Now that was after negotiations, but it ended up with that particular number. Instead, each country would put forth its voluntary pledge, called its nationally determined contribution, its NDC. And so in Paris, or right before, or right afterwards, countries put forth their NDCs, and everybody knew that they weren't enough, that the NDCs did not add up to sufficient emission reductions to meet the temperature targets. But there was built into the agreement a ratchet mechanism. The idea is that every few years, the world would do a stock take, would look at how we're doing, and every 5 years, countries would communicate their new or updated nationally determined contributions with the hope that by 2050, there would be net zero emissions on a global basis. So that was the theory. In the Paris climate talks, the draft agreement said that the temperature objective should be 2 degrees centigrade. In other words, that global average temperature, the global average temperature should be no more than 2 degrees above the average of pre-industrial conditions. But the small island states, which were very active in these negotiations, said that's not good enough because at 2 degrees we're underwater. So they were able to persuade the convention to ask the Intergovernmental Panel on Climate Change, the IPCC, which sort of the world's definitive body on climate science, to take a look at the difference between 1.5 degrees and 2 degrees. And the IPCC came out with a report in 2008 saying that we really need to keep to 1.5 degrees. That terrible, terrible things happen at 2 degrees. And so the international consensus became 1.5 degrees, and that was the objective. I think I saw a hand up earlier. Was it Matt? Do you still have a question?
Oh, yes, thanks. Yeah, I was just wondering what happens to the graphs if we add in, or have you added in shipping and the military
So shipping and aviation,
and aviation, yeah.
yeah, shipping and aviation add up to about 3% of global greenhouse gas emissions. So they're far from trivial. But one significant aspect of the Kyoto Protocol and of the Paris Climate Agreement is that they leave regulation of shipping emissions to the International Maritime Organization, the IMO, and they leave regulation of aviation emissions to the ICAO, the International Civil Aviation Organization. Those are both UN bodies. There's a widespread view that those bodies are largely captured by the industries they regulate. The International Maritime Organization was about to issue a set of rules that would basically impose a global fee on shipping emissions, but the Trump administration objected to that and basically forced the IMO not to adopt that. So we don't have that. So the short answer is that we have only feeble global regulation of emissions from shipping and from aviation.
And do you mean that they're not counted as well?
I'm sorry?
Do you mean that when you say they're not, this feeble regulation, but does that mean that they're not counted as well in a lot of summaries?
The emissions from international shipping and global aviation are included in the overall picture of what global emissions are, but they're not attributed to particular countries. And
Yes.
so there's a large volume of shipping from China to the U.S., and that isn't counted against either China or the U.S. in under any of these agreements.
Thanks.
I have one quick clarificatory question about the statistics you showed. Were they strictly CO2 or were they CO2 equivalent? Because, for example, when the US showed the decline, you said that is largely because of gas fracking going from coal to gas. Now that increased methane emissions but decreased CO2 emissions. Is that included, or is that are the diagrams that you show focused only on CO2?
So this is just CO2.
Just CO2, and
that's right. Now you make an important point about methane, that fracking has what are called fugitive emissions of methane. But one problem is that that's not very well counted. There's been a lot of dispute about just what is the magnitude of methane emissions from fracking, and they're certainly far from trivial. And there are some competing studies about that. There's a debate about to what extent do the fugitive methane emissions from fracking and other natural gas operations sort of overcome the CO2 advantage that they have. I think generally they don't completely, but they do partially. But that is an important point. So in terms of where these agreements have all taken us on a global basis, what this shows is these are the levels of carbon dioxide, and this is just carbon dioxide, but it's the dominant greenhouse gas, the levels of carbon dioxide in the atmosphere, going back to 1960, and it goes up and up and up every year, as it must. It's basically cumulative, because CO2, once it's there in the atmosphere, stays there like a century. The stripes show global average temperatures. Red is warmer, blue is cooler. And then we have these various UN climate conferences. And it's very clear that the climate doesn't care what the UN conferences say. We keep on having higher levels of carbon dioxide in the atmosphere and of methane and nitrous oxides and all the other greenhouse gases. And it gets warmer and warmer despite all these agreements. Now, it could be that without these agreements, this curve would be even higher. We don't know that. But clearly, in 1992, when the UN Framework Convention was negotiated, they had hoped that emissions would peak by 2000 and would start going down, but that certainly hasn't happened. What is likely to happen going forward? An organization called Climate Action Tracker makes these projections, and so this goes back to 1990. These are what the actual emissions have been. When we add up the Paris climate pledges, the nationally determined contributions, and just look at what is actually happening, not just what the pledges are, but actual policies that are in place, it leads us by the year 2100 to this range with an average of about 2.7 degrees centigrade, compared to the 1.5 degree objective that we have after Paris and the IPCC study, and some other studies using different methodologies have come to about the same conclusion. If all the pledges, if all the NDCs are carried out, it would take us to about 2.1 degrees. There's sort of an optimistic scenario where people go beyond that. It would take us to 1.9, but where we really would want to be is down here at 1.5 degrees, and we are way off what the objective is. So we have a gap, both in terms of pledges, the gap between 2.1 and 1.5, and we have a gap between the pledges and actual action. So we are not doing so well. The Climate Action Tracker also rates different countries by their performance in reducing greenhouse gas emissions and meeting the Paris temperature objectives, and they update it every few months. This is the latest update, just came out this month. And we see that by their calculation, no country, none of the 40 or so countries they analyzed here, is acting in a way that is fully compatible with the 1.5 degree objective. That there are several countries here that are almost sufficient, but when we look at these countries, the only one that would be considered a fully developed country is Norway. And the irony is this is just counting their territorial emissions. Norway, of course, extracts an enormous amount of gas from the North Sea, which it exports to other countries. So their territorial emissions are pretty good. But if you look at the emissions attributable to the fossil fuel they produce, not so much. These countries are rated here as insufficient. So major countries like Australia, Brazil, Canada, Colombia, the European Union as a whole, Germany, Japan, Kazakhstan, Peru, Philippines, South Africa, Switzerland, the United Arab Emirates, and the UK are all insufficient, highly insufficient. China, Egypt, India, New Zealand, Singapore, and South Korea, and now critically insufficient, now includes the US. A year ago, they were ranking the US as insufficient because the US had in place quite a few policies that attempted to reduce greenhouse gas emissions. But we all know that since January, the US has moved in exactly the opposite direction, trying to maximize both the production and consumption of fossil fuels. So they're rated as critically insufficient, together with Argentina and Indonesia and Iran, Russia, Saudi Arabia, the other countries that are listed here. Another element of the various agreements over the years, including the Paris Climate Agreement, is that the developed countries pledged to be giving at least $100 billion a year to the developing countries to help them meet their climate targets. And that was supposed to start back in the early 2000s, but it took a long time to get to the $100 billion. They didn't get to that annual level of contribution until 2022. And so we have and there's also a lot of question about what really counts here. Is this overstated? So if we look at the various measures that can be used to consider the effectiveness of the international climate agreements, participation, yes. Well, the Paris Climate Agreement has every major emitting country in the world, except that President Trump is withdrawing the U.S. from Paris, as he did in his first term. But it does have China and India and just about every other country. The ambition of the overall goal, well, the ambition is 1.5 degrees now, so that's great. Achievement of the overall goal, very poor. I showed how things are actually going to achieve that goal. The ambition of particular countries, that's their NDCs. They don't add up to nearly enough. Countries' compliance with the ambition, not very good. I showed you the gap between the ambition of individual countries and the temperature targets. That was a large gap. And the gap between the ambition and what they're actually doing in terms of policy is not so good. Integrity, the clean development mechanism, this international system of wealthy countries paying poor countries to reduce their emissions, major questions about that. Lots of integrity issues. Cost effectiveness. Well, since these agreements are not costing that much, I guess you'd consider them okay on that front. Longevity. The Kyoto Protocol was only to go to 2012, then it was extended to 2020, so that wasn't so good. But the Paris Climate Agreement does not have a sunset date, so I guess longevity is okay. And finally, fulfillment of the financial commitments. The countries have been really behind in meeting the base $100 billion goal, and it's widely regarded that goal is much too low. If we want to think about all these factors, actually the International Climate Agreement that has had by far the greatest positive impact is not overtly a climate agreement at all, but it's the Montreal Protocol on ozone depleting substances. You know, when chlorofluorocarbons and certain other substances are released, they react in the atmosphere in sunlight to create ozone in the stratosphere that degrades the I'm sorry, that eats up the ozone in the stratosphere, and the ozone in the stratosphere is important to block ultraviolet radiation. So it was very important to control chlorofluorocarbon emissions so that we don't have this negative effect on the ozone layer. The Montreal Protocol was fabulously successful. Ozone depleting substance consumption in the world has plummeted since the Montreal Protocol went into effect. Now, there's a problem that the substitutes for it have their own negative impacts, but chlorofluorocarbons have plummeted. And a few years ago, The Economist magazine looked at all the actions that have had the effect of reducing carbon dioxide equivalent, and they rated the Montreal Protocol as far and above the most effective measure that humanity has ever undertaken in order to reduce greenhouse gas emissions. Or that had the effect of reducing greenhouse gas emissions. They ranked nuclear power second, hydropower second, nuclear third. China's then one-child policy is third, all other renewables, and so forth. So you see all of them, but the Montreal Protocol has been fabulously successful. So that's my discussion of the international climate agreements and what countries are doing. Now, before I turn to litigation, are there any other questions about what I've talked about so far? Okay, seeing none, let me move to litigation. So our center at Columbia, the Sabin Center for Climate Change Law, maintains a website with a database that attempts to have all of the climate change litigation in the world. And just 2 weeks ago, we relaunched it with a new artificial intelligence system and search tool that allows it much easier to search our more than 3,000 cases and 15,000 documents, to do full text searching and lots of other searching of all these documents. So anyone who wants to find any climate case in the world can look on that database. So as of the end of June, we had about 3,100 cases. They were in 55 different countries, plus 34 international courts and regional tribunals. 62% of the cases are in the US, and about 10% are in the global South. So looking at the total number of cases from different countries, so the US obviously far and away number one. Australia is a very distant second. Brazil is third, although it's rising fast. There's currently a large volume of climate litigation in Brazil. UK is fourth, and then we see smaller numbers in these other countries, and then a bunch of countries have just one or just a few. On a global basis, we can see that climate litigation really started taking off around 2007. And so this bar chart shows the number of new cases filed. Green is the US and orange is everybody else. New cases filed peaked in 2020, but most of these cases are still pending. So the amount of global climate litigation going on is very, very high. Since the US has by far the largest number, I'll spend a few minutes talking about that before I move internationally. So in the US, by far the largest portion of our cases are under the National Environmental Policy Act, NEPA, our federal law that requires environmental impact statements for significant federal actions, and also the state equivalents of NEPA, mostly California. So that's by far the largest number of cases. We also have a lot of cases under the Endangered Species Act and other wildlife protection laws, under the Clean Air Act and other laws. There's a small number of cases, relatively small number of cases, bringing common law theories and public trust theories and related theories, but those receive a lot of attention. And so of those, we have more than 30 lawsuits pending around the country, brought mostly by states counties and towns against the fossil fuel companies seeking money damages. These cases started, the precursor started in 2000, rather in 1994. I'm sorry, in 2004, and then a new round happened in 2017. None of these cases has gotten to trial. There was litigation for years about whether they belonged in federal court or state court. They ended up in state court. All eyes now are on Boulder, Colorado's lawsuit because it survived the Colorado Supreme Court, and the oil companies are trying to get the U.S. Supreme Court to review it. So we'll see what happens with that. Additionally, Vermont and New York each passed what they call their climate superfund laws that are seeking to assess the fossil fuel companies for their past emissions to help pay for climate adaptation measures. President Trump doesn't like any of this, and he's directed the Department of Justice to try to challenge these. And so they have brought lawsuits challenging the state actions, suits against the oil companies, and challenging the state climate superfund laws. So these challenges are still in their early stages. Other prominent litigation happening around the U.S., the pro-climate cases, the cases that are trying to fight climate change, a lot of lawsuits challenging the actions by the Trump administration in canceling grants and taking away money for climate and clean energy and other activities. Suits challenging the executive order that President Trump issued his first day back in office, declaring an energy emergency. Now, one of those suits was just dismissed last week, a suit called Lighthizer versus Trump, in which the federal district court in Montana said that it didn't have the power in this kind of case to throw out an executive order. Litigation over the Trump administration's halt to a lot of renewable energy projects, large offshore wind and onshore wind and solar, lawsuits challenging his revocation or weakening of regulations, lawsuits challenging the siting of fossil fuel facilities. On the other side, the anti-climate cases, I would call them, are there lawsuits challenging the state superfund laws. California has adopted an important climate disclosure law. The Securities and Exchange Commission had adopted a regulation, but it's being withdrawn by the Trump administration. But California has adopted a strong securities law, and not only securities, but other disclosure law that's been challenged in court. Although so far, the California laws are doing pretty well in court. There are some cities and towns have banned natural gas use or in new buildings, and that's being challenged in court. So that's some of the most prominent U.S. climate litigation. Let me now move on to climate litigation around the world. And I would say the most prominent victory that's been achieved outside the U.S. was in the Netherlands, a case called Urgenda Foundation versus State of the Netherlands. And the Supreme Court of the Netherlands in December ruled for the plaintiffs and directed the national government to cut the nation's greenhouse gas emissions 25% from 1990 levels by the end of 2020. The government had made a pledge of 17% reduction. The Supreme Court of the Netherlands said that's not good enough. And various human rights agreements and doctrines of Dutch law said that the Dutch government needed to do a lot more than that. This decision, and actually the initial trial court decision from 2016, inspired a lot of other lawsuits around the world seeking comparable kind of relief, or otherwise going after national governments for not doing enough to fight climate change, and in some cases going after corporations. So we now have close to closing in on 1,000 lawsuits on climate change elsewhere in the world outside the U.S. And sort of the principal types of cases that we're seeing outside the US that are aligned with the fight against climate change. Similar to our National Environmental Policy Act calling for consideration of climate and greenhouse gas emissions in decisions on projects, challenges to fossil fuel projects themselves, government framework cases, which are like the Urgenda case, saying that the national government should do more to reduce greenhouse gas emissions, polluter pays lawsuits going after fossil fuel companies and greenhouse gas emitters. And here I have to say, so far, there has not been a single court decision in the world holding a fossil fuel company financially liable for its greenhouse gas emissions. Not a single one of these cases has gotten to the finish line. A bunch are still pending, but so far we don't have any liability for fossil fuel companies or for other greenhouse gas emitters for their greenhouse gas emissions. Obviously, fossil fuel companies have been held liable for oil spills and lots of other things, but not greenhouse gases. Corporate framework cases that are trying to make corporations do more. Failure to adapt cases for a country or some entity is not taking sufficient precautions against the physical impacts of climate change. Climate washing, which is a form of greenwashing, where companies claim that they are doing more to fight climate change than they really are. And just a few days ago, Total Energy, a big French energy company, was found liable for climate washing, and a few suits against financial institutions for not taking enough care about their investments, although none of those cases has so far succeeded. Two very prominent cases against private corporations that received a lot of global attention. Mea Defensi versus Royal Dutch Shell. The same people who brought the Urgenda case that I mentioned also sued Royal Dutch Shell. The trial court said that Shell had an obligation to reduce its direct emissions and its indirect emissions, such as those of its customers, the people who buy their gasoline, by a large percentage point. The trial court ruled for them. The intermediate appellate court ruled against them, said it didn't have that power, and that case is now being appealed to the Supreme Court of the Netherlands. Lua versus RWE, a farmer in Peru, said that his farm is endangered by the melting of a glacier near his farm, that RWE, which is the largest electric utility in Germany, is responsible for 0.5% of the global load of greenhouse gases in the atmosphere, and therefore they should pay him 0.5% of his damages. Obviously, that was a case brought for the principle of the thing, that the money would only add up to about $20,000. Both of these cases were dismissed. The companies did not have, were not liable in those cases. But in both of these cases, there were important legal findings from the courts that companies do have a legal obligation to control their greenhouse gas emissions. And sort of set forth a blueprint for future cases that may be brought. There are also lawsuits going in the other direction. There are some lawsuits challenging government regulations on climate change, and quite a few investor-state dispute settlement tribunal cases. And so if an industrial company is working in a particular country, and that country has entered into an investment treaty with another country not to interfere with investment, and the country where the investment is happening is saying you can't build a new coal-fired power plant or something else like that, the companies are challenging the countries in these settlement tribunals. There are challenges to clean energy projects like wind and solar, sometimes brought by environmental groups. And so we call that green versus green litigation. Backlash against ESG, SLAP suits, strategic litigation against public participation. There's several of those. Finally, let me talk about some cases before international tribunals. And just in the last year and a half, we've had very important decisions from the European Court of Human Rights and the International Tribunal for the Law of the Sea and the Inter-American Court of Human Rights and the International Court of Justice. All four of these have issued important decisions that were all celebrated by the environmental community that are very strong in the fight against climate change. And then in May, a new petition was filed with the African Court on Human and People's Rights. We don't have a decision on that yet. So the case before the European Court of Human Rights was brought under the European Convention on Human Rights. And the principal element of that that was relevant here was Article 8, which says that everyone has a right to respect for his private and family life, his home, and his correspondence. And there shall be no interference by a public authority with the exercise of these rights. So a suit was brought by a group of elderly Swiss women against the government of Switzerland, claiming that greenhouse gas emissions have increased heat waves, that these women have health conditions that make them especially vulnerable to heat waves, and saying the country should do more to reduce their greenhouse gas emissions. The court said, yes, that's right. Switzerland needs to do more. Article 8 of the European Convention on Human Rights encompasses the right to effective protection by the state authority from serious adverse health effects from climate change. And Switzerland has been failing to comply with its obligations concerning climate change, doing too little to reduce its greenhouse gas emissions. Now, the Swiss government did not react so well, and they're not necessarily complying with this. And so that's one of the overall problems with these international tribunal decisions, that they are, for the most part, advisory opinions and are not automatically enforceable. An organization called the Commission of Small Island States on Climate Change and International Law filed a petition with the International Tribunal for the Law of the Sea. And that case was largely brought under Article 194 of the UN Convention on Climate Change, which says states shall take all measures that are necessary to prevent, reduce, and control pollution of the marine environment from any source. So that tribunal said, yes, greenhouse gases are pollution of the marine environment within the meaning of the convention, and that the countries that are parties to the convention must take all necessary measures to prevent, reduce, and control marine pollution from anthropogenic greenhouse gas emissions. The countries of Chile and Colombia filed a case with the Inter-American Court of Human Rights on climate change, and that court issued a decision this past July saying there is a human right to a stable climate. A stable climate is essential to the exercise of a wide range of fundamental rights. It's there to protect present and future generations. They recognize the rights of nature. They recognize special protection should be granted to vulnerable groups. Every country must set an emission target consistent with the 1.5 degree Paris target. The countries with the highest historical emissions and highest current emissions and highest level of development must take the lead. And then various other findings, all of which are very positive from a perspective of fighting climate change. Then finally, the UN General Assembly was petitioned initially by Vanuatu, one of the Pacific Island states that's most vulnerable. Several other countries joined in. In order to get to the International Court of Justice, it's necessary to have a majority vote of the UN General Assembly to send it there. In March, that happened. There was a consensus vote by the members of the UN General Assembly. Nobody dissented. So it went to the ICJ, and they issued their decision on July 23rd of this year. It was a lengthy and very strong decision that said all states must take all necessary measures to prevent significant harm to other states. The states must adopt and implement robust plans aligned with limiting warming to 1.5 degrees, that a progressive strengthening of measures is required, no backsliding is allowed, that the developed countries must take the lead in mitigation and support, and duties to future generations must be recognized. So these are a series of very powerful decisions, but they're not really directly enforceable. That's left to the domestic courts, to the courts of each country. But what we're now expecting is that we already have quite a few of these cases in domestic courts, and I think there are going to be more of them, and they'll be stronger, because in many of these other countries, not in the US, but in many of these other countries, the courts take very seriously their obligations under international law, and they take seriously the kinds of obligations that the International Court of Justice and these regional courts declare. So I think I'll stop here and invite any questions that anyone has.
Super. Many thanks, Michael. Are there any questions? Matt.
Hello. Yes, I'm wondering, is there much to report on the history of action, climate action, litigation about deforestation?
Yes, well, certainly deforestation is responsible for maybe 20%, 15, 20%, something like that, of global greenhouse gas emissions. And it's something that has also been addressed throughout the years of the UN climate conferences. The country with the largest amount is Brazil, and their performance goes up and down depending on who's in power. So under Bolsonaro, there was a lot of deforestation. Lula, now that he's back, there's a lot less. Indonesia is another important flashpoint here, and some other countries. So there has been some progress, but we don't seem to be anywhere near where we want to be in terms of reducing deforestation.
I mean, is there potential perhaps for litigation in rich countries about relationships with poor countries and the effects on deforestation in poor countries?
I could imagine that under some of these new international rulings, like the International Court of Justice, that cases could be brought against national governments based on that theory, that the countries ought to be not only reducing their direct in-country greenhouse gas emissions, but also their consumption of goods that lead to deforestation. You know, one of the largest causes there is growing soy and other animal feed for beef cattle. Also, a lot of deforestation for palm oil and other oils. So we haven't yet seen that kind of litigation, but it's possible that we will, but we don't see it yet.
Thanks.
Is there any prospect that now with the Trump administration in power that there will be legal progress on the international level without the US? Right? The US has often acted as a diluter and brakeman in international agreements. And now that they are very obviously not going to join any such agreements, there may be more of a willingness by other countries to try to go it alone and try to create a coalition of the willing of sorts with new legal instruments. Is there anything on the horizon like that?
Well, we don't yet know what the net effect will be. It may inspire some countries to go it alone. It may inspire some other countries to say, well, if the richest country that's the biggest historic emitter isn't doing much, why should we? We don't know how that's going to turn out. Of course, the next UN climate conference is coming up in a couple of weeks in Brazil. And the US is going to play a negative role. What they did under the first Trump administration is the US lined up with Russia and Saudi Arabia to form a coalition to try to block action. That may happen again. Ironically, the country that is really taking the lead now for the most part is China. And China is certainly the global leader in wind and solar and electric vehicles and batteries and everything else, although they are also still building a lot of coal-fired power plants, both domestically and abroad. So that's a very mixed story. But there's no question that the U.S. has abandoned any leadership position in the climate world.
Carol?
Yes, thank you very much for your presentation. I have actually two questions. The first one is on the climate litigation database. I'm curious about the process of collecting such a large number of cases. Have you encountered any challenges in this process? Did you rely on national or local law firms or university to assist with data collection? And the second
Why don't I
question,
answer let me answer the first question, and then you can
yes,
so that I don't forget it. We
Yes.
started with just the US cases, and it's easy to track those because of various computer databases. It's more difficult internationally, especially if the cases aren't in English, and especially if they're in a different alphabet. So we've assembled a group of about 80 rapporteurs, lawyers in other countries around the world who send us cases. So they keep track of the cases that are happening there, and other people who know about our database send us cases. So I can't guarantee we have every case, but it is unquestionably the most comprehensive collection of the cases, and I think we have the great bulk of them.
Yes, totally. It's an amazing tool. So my second question is more on the first part of your presentation. There was a slide on measures of effectiveness of international agreements. If I'm not mistaken, you mentioned, among others, the ambition of countries and countries' compliance with ambition. So my question is on the term ambition. So is that a target, a legal obligation, or something more related to soft law? Because it looks to me that we are still having this kind of hybrid framework where hard law and soft law reinforce each other. So is that true?
Well, and the ambition here is basically talking about their NDC pledge. And in different countries, one consider the NDC pledge hard or soft. And so some of the courts have interpreted the NDCs as actually binding on their countries. That is not the case in the US, but in some countries it is. But that's what the ambition is referring to.
Thank you very
much. Question from the audience? So then I will ask another one, if I may, and that is sort of a little bit unclear question, namely, how important do you think is the legal strategy in trying to solve the problem of pollution and climate change vis-a-vis other strategies, like, for example, the political strategy, where you try to go through the parliaments and political parties, and the science/technology strategy, where you are trying to develop new technologies and try to diffuse them so as to make alternatives cheaper and maybe the fossil fuel ones more expensive. So you said at some point that the international courts, their decisions often do not have much bite. They don't really have much of an effect because they're largely advisory. But on the whole, looking back at all the court cases that you have looked at, how much of an impact has all of that really had?
Well, we clearly need all three. We need the legal strategy and the political strategy and the scientific and technical strategy. In the US, there was a landmark decision from 2007 called Massachusetts versus EPA, which was extremely consequential. It basically indicated that the Obama administration and then the Biden administration had the power to use the Clean Air Act to regulate greenhouse gases. So that was very, very important. Litigation has stopped a lot of bad projects, coal-fired power plants and pipelines and so forth. But it has had a political effect. I would say that of the three buckets you mentioned, it's number three. I think everybody who wants climate action in the U.S. Thinks that we really need congressional action, and we did have some congressional action for a while with the Inflation Reduction Act, much of which has now been repealed under the Trump administration. But this litigation can help drive political action, and it can have some impacts on its own. It is useful, but it is not the single most important thing by far.
Thank you. Any other questions from the group? Matt?
I'm wondering If you were advising activists to take on new types of cases, what would you advise?
Well, it would depend entirely on where they are and so forth.
Sure, yes. But I
but
mean, what sort of things might have the largest effect, and maybe in which countries?
I think challenging specific fossil fuel projects has been really does have notable successes, and that can be very helpful. So that's one area that I would focus. In the U.S., what we now need to do is defend the gains we've made, and so a lot of the litigation currently is against the Trump administration for weakening regulations and withdrawing grants and that kind of thing. But it's very much a country-specific kind of question.
Right. And as a footnote to Matt's question, cases can be won and they can be lost. And if they are lost, they could have a negative effect, right? It could be that they set a precedent that is actually going to be unhelpful, because instead of being afraid of being sued, companies might now have assurance that they can do certain things with impunity, for example. So one more question on that point. Do you provide assistance in any way? I mean, when people think about bringing a lawsuit, might they come to you and get some advice? And might you, in some cases, advise them this is probably not going to work and it's probably going to be counterproductive or at best a waste of money? So better try to use this other mechanism, or better find another thing to litigate.
Yes, we do hear from people and try to, on an informal basis, give them our thoughts if we can. We don't undertake lawsuits ourselves, although we do file amicus briefs from time to time. But I have talked to people thinking about litigation, and sometimes I've encouraged them and sometimes I've discouraged them on the bases that you just mentioned. I'll also say that some cases that seem to lose actually accomplish a lot. So I mentioned the Neo Defensive versus Shell case and the Lua versus RWE case. They both lost in that they didn't get the plaintiffs didn't get the relief they want, but some important legal principles were set forth.
Mm-hmm. So they were on the whole positive, you think?
Yes.
Despite the fact that the plaintiffs lost.
That's right.
Good. Last chance for anybody in the audience to get a word in edgewise. We have been at this for 6.5 hours, so people are a little bit tired, but we had I think, a wonderful day. And thank you very much, Michael, for being here with us. But let's give it another 2 seconds just to see whether there's anybody in the chat or anybody. Nope, I don't think so. So remains to thank you very much, Michael, for sharing your wisdom with us and for doing this very important and interesting work, really unique in the world. And you're a leader and a leading institute in doing this.
Thank you so much. It's been good.
Right.
Everybody have a good day. Bye.